Hello everyone, my name is Adeola Kolawole of aaLawsng. So we want to continue with our April law series, which the main focus is on tenancy matters. So today we're going to be talking about, as earlier mentioned in previous videos, on the fact that tenancy agreement is very important. Like, it's very important because it provides for, it has a lot of provisions that just protect either the, it can be the landlord or the tenant, and protect both parties. Now, so one of the provision of tenancy law, I know, and I mentioned earlier that I was going to be using tenancy law Lagos State as a reference for the generality of other laws, because most of these provisions are similar. Now, it said that where there is no stipulation as to the notice to be given by either party determining tenancy. So what are they saying is that if eventually you have a tenancy agreement and it wasn't stipulated how the term means end in the tenancy contest, to determine something means to end, to put an end to the tenancy. So if there's no stipulation as to how you want to determine tenancy, this would apply in the tenancy law. But if you already have, so for example, your landlord gives you a tenancy agreement and states that if you do not pay, maybe after 6 months or after a certain period of time, you'll be given a 3-month notice, even as a yearly tenant, or you'll be given a month notice, even as a yearly tenant, and you read that, signed, that's what will apply when it's time to get a notice. That you won't therefore come back and say, no, this is what the law says. The law says I'm a yearly tenant, so I'm entitled to a 6-month notice. No, because you saw it in the first place. If you had wanted to disagree with the landlord, you ought to have complained at that time that, no, why not give me something? Why not give me more time, before you signed the document? But if you after you signed, there's no room for complaint. So why are we saying that if it is otherwise, you don't have provisions for the same thing apply, even if it's a month notice that is there and you sign. But I realize that many times that this notice, the tenants probably have not even, they didn't even read that part. So it's when the situations happen, it comes done, like the lawyer or part of the landlord will now write to you. I'm like, where is this coming from? And they refer back to the tenancy agreement that, okay, this has actually been provided for in the agreement. So, but if not stated at all in the tenancy agreement, then what would apply would be a week notice for a tenant at will. So I'm going to explain tenant at will subsequently. So a month notice for a monthly tenant, a 3-month notice for a quarterly tenant. So sometimes the landlord can decide to collect monthly rent from you every 3 months. Same 3 months apply to someone that pays every 6 months, and 6-month notice for a yearly tenant. So that's it. But this would not apply if it's otherwise stated, if you have provisions in your tenancy agreement that provides for how your tenancy will be determined. Then another thing, and I also noticed the fact that